I'm uncomfortable with the last paragraph. The itemized bill of the board's attorney is subject to attorney-client privileges provided under law and may only be viewed by board members. No copies will be permitted. I think that there ought to be some information released, as we discussed earlier tonight, to the public while protecting names and confidential things.
Well, but see, what we talked about doing tonight would not violate this, because this would talk about copying the itemized bill of the attorney. And what we talked about doing tonight is releasing percentages, like this is discussions of employment issues, discussions of whatever the numbers were. That's not the same as releasing the itemized bill. That would say, Dr. Gerber talked with Doug Mann about employee XYZ. I mean,
right. And I don't want to release that, but this last sentence says only the cover page of the bill, after it's properly redacted, may be released in compliance with the Open Records Act request. I think that there ought to be.
Well, what's wrong with that? Because if you don't put that, we've had a bunch of open records requests already asking to see those itemized bills. They should not be released to the public. I don't want anybody seeing what legal issues we discussed. I mean, I don't mind them knowing that we talked about real estate, but we don't need anybody seeing which parcel of land we're thinking about borrowing. What if they go buy it and price it?
Obviously, I mean, that's patently obvious. However, I probably was a legal law seminar last fall out at Riverside. I asked Drew Edmondson specifically, what about releasing attorney, detailed attorney bills? And he said, and this was not a formal opinion by any means, he said he felt like they were included in the Open Records Act with redacted information. So there is some room.
But every school attorney present said they wouldn't do that. Every school attorney present. OSSBA said they wouldn't do it. Stephanie Mather said she wouldn't do it.
I didn't hear them discuss that. They said they wouldn't recommend taking executive sessions, which you think that also.
Yeah, maybe it was that one.
Yeah, that's what. So I'm concerned about putting this in policy if we can change it, I guess. That's one of my concerns.
Or if the board's pleasure were to continue to look into it, as what you said, you could remove the last sentence. Because the front page, Mrs. Whippo, on the bill that we received from RFR clearly states. The rest is not such.
Yeah, that's true.
So, I mean, that tells the public, when we give them what they ask for, at least a bill, that our attorney says nothing else is subject to open records.
Yeah, but if we put this in the policy, then the public will know that maybe they should quit asking us for that. It's a waste of their time and ours to keep asking for it when the policy says you're not going to give it to you. So I see some value in that. I mean, if that's going to be our attitude. If we're going to release I don't see any value in releasing copies of the legal bills. I mean, I really don't want, there's nothing that the public needs to see in there. If they want to know that we talked about real estate law, okay. But I don't really want them knowing about the potential lawsuit that we avoided 2 weeks ago, and giving them fill that out, or 6 months ago, or whatever the heck it may be. So, I just don't think that's going to benefit the public or anyone else if they start digging in and find out, they avoided a lawsuit yesterday. They avoided a lawsuit last week. What might that have been concerning? That's not going to help any of us out.
Well, I think the public has a right to know coming topics.
And I guess you'll happily incur the additional personal liability that may come with that?
I think it should be maybe that's incur personal liability, but I don't know.
I think we agree to disagree.
I'm right.